The legal and financial tumult surrounding former President Donald J. Trump has entered a phase of unprecedented concrete consequence as a long-threatened cascade of asset seizures has been formally initiated by the state of New York, even as the U.S. Supreme Court delivered a critical, if temporizing, procedural victory for him. This dual development creates a stark portrait of a legal battle being waged on multiple fronts with staggering speed and high stakes, where judicial protection in one courtroom is immediately juxtaposed with enforced collection in another. The triggering event is the final expiration of a grace period following a staggering civil fraud judgment, an expiration that has compelled the New York Attorney General's office to begin the complex process of claiming control over some of the most iconic properties associated with the Trump name. Simultaneously, the Supreme Court's intervention in a separate but profoundly consequential criminal case has granted Trump a significant reprieve, ensuring his federal election subversion trial will not proceed in the immediate term and reinforcing his ability to claim presidential immunity as a defense. The collision of these two legal trajectories, one affirming state-level accountability with immediate financial fallout, and the other delaying federal criminal accountability on grounds of untested constitutional principle, frames a historic moment for the American legal and political system. The immediate and tangible action is unfolding in New York, rooted in a verdict now several weeks old. In February, following a protracted trial, Judge Arthur Engoron found Donald Trump, his adult sons, and the Trump Organization liable for a systematic pattern of business fraud. The core finding was that Trump and his executives persistently and deliberately inflated the value of assets like golf courses, hotels, and skyscrapers to secure favorable loans and insurance terms, reaping hundreds of millions in ill-gotten gains. The penalty was catastrophic from a financial perspective, a disgorgement of those gains plus interest, totaling approximately $464 million, with Trump personally responsible for the overwhelming majority. A critical component was a 30-day window granted to the defendants to arrange for the payment, either from cash reserves or by securing a bond from a licensed financial institution. That window closed without the full bond being posted, despite frantic and public efforts by Trump's legal team to find a surety company willing to underwrite such an astronomical sum. The Trump Organization reported encountering a practical impossibility in the marketplace, arguing that bonding companies would not accept real estate as collateral but required cash or cash equivalents, which Trump claimed he did not possess in full liquid form. The failure to secure the bond activated the New York Attorney General Letitia James's legal authority to begin enforcing the judgment. Her office, having already filed the judgment in Westchester County, New York, effectively put the state sheriff departments on notice to act as its agents. The first visible move was the formal filing of notices of lien, known as sheriff's deeds, on two major properties, Trump National Golf Club, Westchester, and the sprawling Trump-owned estate known as Seven Springs in Westchester County. These legal instruments are not immediate foreclosures or forced sales. They are the foundational legal step in that process, formally asserting the state's claim over the property to satisfy the debt. They encumber the title, preventing sale or transfer without satisfying the lien, and initiate a procedural countdown that could lead to a sheriff's auction. Perhaps more symbolically potent was action regarding 40 Wall Street, a towering skyscraper in lower Manhattan, long considered a crown jewel of the Trump real estate portfolio. The Attorney General's office took the preliminary step of filing the judgment with the New York County Clerk, a necessary prelude to seizing control of the entity that owns the building. Reports indicate agents for the state have been in communication with the building's third-party management company, signaling an intent to assume the flow of rental income generated by the property, effectively diverting Trump's profits to the state. The mechanics of this process are intricate and will unfold over weeks, not days. For major commercial real estate, the path from lien to forced sale is lengthy, governed by strict procedural rules designed to protect due process, even for a debtor found liable for fraud. Appraisals must be conducted, additional legal notices filed, and public auctions advertised. The Trump legal team is expected to challenge every step, filing appeals and motions to stay enforcement. However, the initiation of the process itself is a profound blow, both financially and to the brand identity Trump has cultivated for decades. The image of the successful deal-making billionaire is now publicly juxtaposed with court documents. authorizing the government to take control of his properties to pay a debt ruled to be born of fraud. The Attorney General has been clear that her office is prepared to pursue the seizure of any asset necessary to satisfy the judgment. And while she has stated a preference for cash, the list of potential targets is long. Bank accounts identified through subpoenas, other golf clubs, even the iconic Trump Tower on Fifth Avenue, each move will be met with fierce legal resistance, turning the process into a protracted, piece-by-piece legal war of attrition over physical assets. This dramatic enforcement action in New York exists in a parallel universe to the seismic developments at the United States Supreme Court. There, Trump's appeal of a federal appeals court decision, which had flatly rejected his claim of absolute immunity from prosecution for acts committed while in office, was granted a hearing. The court's decision to take the case and its subsequent scheduling of oral arguments for the final week of April automatically placed a hold on the underlying criminal trial being prosecuted by special counsel Jack Smith. That trial, concerning Trump's actions to overturn the 2020 election results, was slated to begin in early March in Washington, D.C. It is now indefinitely delayed, likely until late summer or early fall, at the absolute earliest, and potentially until after the November presidential election. The Supreme Court's move is, in a procedural sense, a victory for Trump's legal strategy of delay. By agreeing to hear the immunity question, the conservative majority court has validated his right to present the argument, something the lower appeals court treated as a matter of settled law, not meriting extended debate. The constitutional question at the heart of the Supreme Court case is profound and untested: whether a former president enjoys immunity from criminal prosecution for official acts undertaken while in office, and how to delineate official from private conduct. Trump's legal team asserts an expansive view of immunity, warning that without it, presidencies would be crippled by the threat of politically motivated prosecutions from subsequent administrations. The special counsel and many constitutional scholars argue that such absolute immunity would place a president above the law, a concept anathema to the foundational American principle of equal justice under law. The D.C. Circuit Court of Appeals, in a unanimous and forceful opinion, sided with the latter view, stating, "Former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution." The Supreme Court's review now places that definitive ruling in question. The timeline of their decision is critical. A ruling in late June, at the end of the court's term, would leave a narrow window for the election subversion trial to be completed before November. Any decision that requires additional lower court proceedings to apply its ruling to the specifics of the case would effectively push the trial past Election Day. The juxtaposition of these two legal narratives creates a bewildering panorama. In one arena, the state apparatus is moving with deliberate force to hold Trump accountable for civil fraud, a process grounded in property law and financial regulation, leading to direct and immediate threats to his business empire. In the other, the highest federal court has interceded to slow and potentially reshape the criminal accountability process related to his conduct after the 2020 election on grounds of constitutional principle. This duality speaks to the unprecedented nature of Trump's post-presidency. He is simultaneously a civil defendant facing the enforced dissolution of his life's work, and a criminal defendant benefiting from a Supreme Court-ordered pause that could fundamentally alter the scope of presidential liability. The political implications are inescapable. For his supporters, the asset seizures are portrayed as the weaponization of the legal system by a partisan Democratic prosecutor, a witch hunt made manifest in the attempted confiscation of property. For his critics, the Supreme Court's deliberation on immunity is seen as an unnecessary delay that jeopardizes the public's right to a speedy trial on charges of attacking democracy itself, potentially allowing a candidate to return to power while under federal indictment for seeking to subvert the last election. The international reaction watches this schism with a mixture of fascination and concern. Allies and adversaries alike are observing a nation deeply divided over the rule of law and the accountability of its leaders. The sight of a former president and current candidate having properties liened by the state is unparalleled in modern Western democracies, often compared to actions taken against oligarchs in authoritarian or post-Soviet states. Concurrently, the Supreme Court's deliberation on immunity is studied by constitutional scholars worldwide as a test case for the resilience of democratic checks and balances. The global financial community is closely monitoring the asset seizure process for its implications on commercial real estate markets and investor confidence in New York as a stable legal environment. The two stories, while legally distinct, are now inextricably linked in the global narrative of America's political and legal turmoil in 2024, a year of a monumental presidential election. The coming weeks will see the New York seizure process advance through its technical, bureaucratic steps, while the Supreme Court prepares for a historic oral argument. Each path moves forward on its own track, one towards tangible financial reckoning, the other towards a constitutional ruling that could redefine the presidency itself. The intersection of these tracks and their ultimate destination remains the most compelling and uncertain story in American public life. The economic ramifications of the asset seizure process extend far beyond Trump's personal portfolio, sending ripples through the commercial real estate and financial sectors. The immediate focus is on New York City's already turbulent property market. Properties like 40 Wall Street are not standalone entities. They are intertwined with complex debt structures, investors, and tenants. A forced sale or state seizure of such a high-profile asset, especially under distressed conditions, could potentially depress valuation benchmarks for similar Class A office buildings in the financial district, an area already grappling with high vacancy rates post-pandemic. Lenders and bondholders for these properties are now forced to assess their exposure and the covenants in their loan agreements, which often contain clauses triggered by the legal jeopardy of a principal owner. The broader concern for the market is one of uncertainty and precedent. While enforcement of court judgments is routine, the scale, publicity, and political charge of this situation is without parallel. It raises questions for other high net worth individuals and developers about the operational risks associated with legal battles at the highest level of politics, and whether New York's legal environment is becoming unpredictably hostile for high-profile figures. Conversely, proponents of the enforcement argue that upholding the rule of law and ensuring even the most powerful are subject to the same judgments strengthens the integrity of the marketplace by deterring fraud. The social and cultural consequences of these events are deepening the existing fissures in the American body politic. For a significant portion of the electorate, the image of the state moving to seize properties carries a potent symbolic weight. It is viewed not as legal accountability, but as confiscation, a deliberate dismantling of a perceived political opponent's legacy and livelihood by a Democratic-led state apparatus. This narrative fuels existing grievances about the weaponization of government and reinforces a sense of partisan persecution, further entrenching support for Trump as a figure under siege. On the other side, for those who see the civil fraud judgment as a long overdue reckoning for a businessman who operated with impunity, the seizures are a validation of the principle that no one is above the law. The spectacle underscores a fundamental clash in perceptions of justice itself. One side sees a corrupt system finally acting, the other sees a corrupt system attacking. This division is reflected in media ecosystems, with coverage starkly bifurcated along partisan lines, making a common shared understanding of the facts nearly impossible. The situation becomes a Rorschach test for Americans' views on equity, wealth, and legal privilege. Internationally, governments and analysts are observing these parallel proceedings with a mixture of analytical interest and diplomatic caution. For European allies, the spectacle is a source of continued bewilderment and concern about the stability of their most powerful ally. The blending of deep legal troubles with a presidential campaign is a phenomenon largely foreign to parliamentary systems, where leaders typically resign under far less scandal. The asset seizures, in particular, draw comparisons to actions taken against oligarchs following Russia's invasion of Ukraine, though with the critical distinction of being directed by an independent judiciary following a trial, not by executive decree. In authoritarian states like Russia and China, state media leverages the turmoil to bolster narratives of American decline, hypocrisy, and democratic dysfunction. They point to the events as evidence that the U.S. system is as politically vindictive and unstable as any other, undermining Washington's moral authority to advocate for the rule of law abroad. For global financial centers like London, Hong Kong, and Dubai, the case is a clinical study in jurisdictional risk. It underscores the potential vulnerabilities of assets in jurisdictions with aggressive prosecutorial authorities, potentially influencing where international wealth seeks safe harbor. Expert legal analysis emphasizes that while the New York enforcement action and the Supreme Court immunity case are procedurally separate, They are philosophically connected by the theme of accountability mechanisms. Constitutional scholars note the Supreme Court's decision to hear the immunity appeal, while procedurally granting Trump delay, also carries inherent risks for his broader legal position. The court could issue a ruling that is far narrower than the absolute immunity he seeks, potentially creating a roadmap for the prosecution to proceed swiftly on acts deemed unofficial. Furthermore, the court's conservative majority, including 3 justices he appointed, may be reluctant to establish a sweeping precedent of presidential criminal immunity that could apply equally to future Democratic presidents. Meanwhile, civil procedure experts highlight that Trump's options in New York, while narrowing, are not exhausted. He can still seek emergency relief from an appellate court to stay the seizures pending appeal, though such a move would almost certainly require posting a full bond or a significant portion of it, the very hurdle that triggered the crisis. Another remote possibility is the filing for Chapter 11 bankruptcy protection for the holding entities controlling the targeted properties, a maneuver that would automatically stay collection actions, but would entail a devastating blow to the brand and cede control to a bankruptcy court and creditors. The immediate future is set on 2 divergent calendars. In New York, the Attorney General's office will methodically continue the process of perfecting its liens and moving towards the control of income streams and potential sheriff sales. Each step will be met with legal challenges, but the direction of travel is towards the tangible realization of the judgment. The Trump organization will be forced into a defensive posture, possibly attempting to hastily arrange private sales of assets to generate the cash needed to satisfy the judgment and stop the seizures, a fire sale scenario that could realize prices far below claimed values. Simultaneously, all attention will turn to the Supreme Court building on April 25th for oral arguments in Trump versus United States. The justices' questioning will provide the first clear signals of their stance. A skeptical reception of the absolute immunity theory could indicate a quicker, more limited ruling, allowing the election case to proceed. A receptive bench could foreshadow a more complex opinion that remands the case for further hearings on what constitutes an official act, a process that would consume months, effectively guaranteeing no trial before the election. The political implications for the 2024 presidential election are now inextricably baked into these legal timelines. The delay of the federal election subversion trial is the most consequential development for the campaign trail. It means voters are likely to go to the polls without having seen a jury render a verdict on the events of January 6th. The legal question of immunity will be debated on the stump, not in a courtroom. For the Biden campaign and Democrats, this denies them the clarity of a legal conviction to underscore their narrative of Trump as a threat to democracy, forcing them to rely on the details of the existing indictments. For the Trump campaign, it allows them to frame all 4 criminal cases as politically motivated interference, without the counterweight of a concluded trial. The New York seizures, however, provide a powerful visual and rhetorical tool for Trump to galvanize his base, portraying himself as a martyr whose possessions are being literally taken by the state. This could intensify the populist, anti-system energy of his rallies. Conversely, it may also sharpen the focus on his business practices for moderate and independent voters who see the fraud judgment as a settled matter of law. Historically, the moment finds few parallels. The financial decline of a president post office is not uncommon, but the state-enforced dismantling of a former president's business empire based on a fraud finding is unprecedented. The closest analogs may lie in the realm of political corruption cases against governors or cabinet officials, but never at the level of a former head of state. The constitutional question before the Supreme Court is truly virgin territory. Richard Nixon was granted a pardon, sparing the system a test of prosecuting a former president. The current situation is a stress test of every pillar: the judiciary's independence, the durability of business and election laws when applied to a presidential candidate, and the public's capacity to absorb a continuous stream of legal and political shock. The system is navigating terra incognita, with procedures being forged in real time. The ultimate outcome will establish precedents that will define the contours of presidential power, accountability, and the intersection of wealth and politics for generations. The weeks ahead will be a meticulous procedural dance in New York courtrooms and a high constitutional debate in Washington, all unfolding under the relentless glare of a presidential campaign, each step resonating with profound consequences for the nation's identity and its democratic future. The world watches, aware that the results will echo far beyond court dockets and property ledgers, touching the very core of how the United States governs itself and is perceived on the global stage.